Oh, this is. Oh, okay.
All right, this is case number 21-153-722. This is Highland Towers Associates LLC versus Jacqueline Fears. The matter is before the court, set on for review on today's date. For the plaintiff, your appearance at this time, please.
They're still in that breakout room.
Oh, they're in the breakout.
Yeah.
All right, thank you. I'll come back to that matter. The court now calls 21-15-4155. This is Regency Tower Apartments versus Deborah Ginwright. Matter is before the court, set on for a motion to set aside default judgment. What I have here, yes. All right, your appearance at this time for Regency.
Good morning, Your Honor. Mr. Popov, 4378, appearing on behalf of the plaintiff.
All right, Madam Court Reporter, I know it broke up a little bit. Did we get it?
Yeah, I have it, Judge.
All right, thank you. Thank you. Good morning to you as well.
Good morning.
All right, do I have Deborah Ginwright on the Zoom? Ms. Ginwright, Deborah Ginwright? All right, and I know that the matter is set on for 9:45 a.m. I do see the correct Zoom number was sent out. Counsel, I'm going to give it just a few more minutes to see if the defendant will come in. We're just 2 minutes after the scheduled time, so I'll wait a few minutes and see if we can get this Ginwright here. Come right back to you. All right, I see someone indicated, I see someone indicated as Nicole on this, I also see Carlos J. Tell me which case you're on, Nicole.
I'm on case number 191-80131.
All right, thank you, ma'am. And that's set for 10 o'clock, so I'll be calling that shortly, ma'am.
Okay, thank you.
Yes, ma'am.
Hello?
Yeah, who are you, ma'am?
I have a 10 o'clock case.
Yeah, who are you?
Sorry, Yvette Murphy.
All right, let me see if I got you here, Ms. Murphy. One moment. Yes, and I do have your case involving objections to garnishment. I'll be calling it at or about 10 o'clock, ma'am.
Okay. Hello? He done muted me.
Yeah, I know that you're there, ma'am.
Oh, okay. Okay.
All right, and we're back on the record regarding Regency versus Deborah Ginwright regarding the suffix 4155. And counsel has entered his appearance on behalf of Regency. The court is looking for Deborah Jenwright, a person living on Wisconsin Street in the city of Detroit. If you are on this Zoom, please say something at this time. The court did review the file. The file indicates that a correct notice indicating the Zoom hearing on today's date with the correct Zoom number. The court has also taken a moment to review the motion to set aside the default judgment, and the defendant indicates in the same she checked off under the motion and affidavit part C, 1C and 2A. 1C, 21 days has passed since the default judgment was entered, but I was not personally served with the summons and complaint. Then secondly, under 2A, the court lacks jurisdiction because I was not served with the summons and complaint. I also took a moment to review the file as to entry of the judgment. And the court did receive a proof of service document filed with the court by a process server one, Quentin Pope, indicating that they personally served the defendant at an address on Wisconsin, and they provided identifying information. I also received the plaintiff's response to this matter, and the plaintiff response to the matter indicates their position that there is a failure to comply with MCR 2.603 B2, where there is not a showing of good cause, an affidavit of meritorious defense. Obviously, when the motion is grounded in lack of jurisdiction or lack of service, then the rules regarding good cause and meritorious defense are treated differently, are handled differently. The challenge here is that contained within the court's file is a proof of service, personal service, and moreover, the defendant has not appeared on today's date. Accordingly, now the court will deny the motion to set aside the default judgment where the defendant has not appeared, and where it appears that there is a proof of service contained in the court's file, indicating that the defendant was in fact personally served. The judgment that was entered on the 2nd of July 2021 will remain in full force and effect. The motion being denied at this time. Thank you, counsel. Good day to you.
Thank you, Your Honor.
Order. You said you need order on it? You said I need order on it?
That's, I denied the motion.
Mhm.
Probably generate.
Okay, all right.
So, All right, do I have the parties on American Medical versus, City of Detroit? That's at 10 o'clock. Yeah. All right, on the record, I previously called the suffix 3722 Highland Towers Associates LLC versus Jacqueline Fears. The parties were in a breakout room. Your comments at this time, Council for the plaintiff.
Good morning, Your Honor. James Zellin appearing on behalf of the plaintiff, P69241.
All right, thank you, Mr. Zellin, and good morning to you, sir. And I see Miss Jacqueline Fears there. Good morning to you, Miss Fears.
Good morning.
All right, so I know that you were in a breakout room, and I know that this matter, I think, is before the court, where an answer has been filed. And it's, I don't think there's much of any other process that has occurred since that time.
Yeah, Your Honor.
Go ahead, sir.
Your Honor, we were here for a control date. Last time we were here, we agreed in principle to a consent judgment. I had submitted that to Miss Fears. She indicated she had just recently got it and had not had a chance to return it to me yet. I have provided her my fax number and email address today. She's going to get that to me today, and I will submit that to the court. So if we could just get another control date, we can, I am confident that that paperwork will reach the court before that date.
All right. That makes sense to you, Ms. Spears?
Yes, yes.
All right. Any questions you have in the court at this time or anything, ma'am?
No, no.
All right. So I will follow that process and adjourn the matter with a notation on the file that has been resolved, and that the court is awaiting entry of an order of resolution in this matter. So we're going to set it over for some 3 weeks.
About 20, 30. You want to do the November the, oh, you want December?
Yeah, I think we have to go to December. All right. Then we can do 13.
Yeah, I mean, okay.
So 12/13 is when I'm going to set it over for that time. I'm optimistic that you've gotten the matter resolved. So 12/13 at 10 o'clock. And if it's resolved, just get the paperwork in, and you won't have to come back on that date. 12/13/21, 10 o'clock again.
Sounds good, Your Honor. Thank you.
Thank you.
right, this is case number 1919, strike that, 1918, 0131. This is Crown Asset Management LLC versus Nicole Dorch. The matter is before the court on the filing of objections to a writ of garnishment. There's also an accompanying motion, an affidavit to set aside a default judgment in this matter. The record should reflect in this case that the judgment was entered by default. That judgment was entered by default on May 18, 2021. The total amount of the judgment is $1,107.91. All right, your appearance for the plaintiff, Crown Assets Management.
Good morning, Your Honor. Adam Berman, P68586, appearing on behalf of the plaintiff.
All right, thank you, counsel, and good morning to you, sir. I understand also that Ms. Nicole Dorch is on.
Yes.
Good morning to you, Ms. Dorch.
Good morning.
All right. These are your matters that bring the case before the court, and you've indicated two things. You indicated two positions that you're taking regarding this case. One is that, of course, a writ of garnishment issue, and you provided objections to the same. You indicated your objections in the court's register. My address is incorrect. I've never received a complaint summons or notice of hearing. I have updated my address and requested the court allow me to respond. I received the creditor. I received from the creditor because the balance of the judgment is wrong, and then I received your affidavit, motion affidavit to set aside default, and you indicate under 1A, a default judgment was entered, under C, you indicate 21 days have passed, you were not personally served, and then 2A, the court lacks jurisdiction, and then 2B, you have good cause for your failure to respond to the complaint. That's the size of what you've indicated to me. Is that correct, ma'am?
Yes, that's correct.
So the information that I have in the court's file was that the court allowed for alternate service in this matter, and the court granted an order of alternate service allowing the plaintiff to serve you by a combination of 3 processes. And one process was first class mail and an address on Ewald Circle by attaching at that location, and also by certified mail restricted delivery. And the court concluded that upon the alternate service process that was sufficient to allow for entry of judgment. That's how we got to the judgment. They could not find a way to serve you personally, and so they used the last known address that they had available and used 3 methods to serve that are allowed under the court rules. That's what happened in this case.
Okay.
You indicated further when you began talking to me that the judgment amount is wrong. So is there some indication on your part that you owe some obligation to this plaintiff, Commonwealth Bank, related to Victoria's Secret?
Yes, I requested validation of the debt, which I did receive. And on the last statement, it shows that I owe $326, but when the complaint was filed, it says $826. So,
thank you, ma'am.
Counsel, these issues, sir.
Your Honor, just for the record, we were not served with this affidavit to set aside the default judgment, so I wasn't sure of what her argument was. I only have the objection to garnishment at this time, which I was going to state is basically attacking the underlying judgment and the default judgment. My response to what was stated on the record just now is that there was the order for alternate service. There was a proof of service supplied with our motion for alternate service stating that the defendant was living at the address as indicated on the complaint at the time. This was in 2019 and 2020, and she was not home at the time. And there was also a valid postal verification for the address. That is how the order for alternate service was granted at the time. So we do have a valid order for alternate service. It was served alternately pursuant to that order, and there was no response filed at that time. So that is my response to the motion to set aside the default at this time.
Thank you. So the defendant has basically postured before the court that indeed she believes that there is an obligation owed herein. But she says she received some information on the accounting that is substantially different from the amounts set forth in the complaint. And of course, ultimately, the judgment is in excess of $1,000. She indicates that that she received validation of the debt and is only $300, really in excess of $300.
Was that a question to me? I'm sorry, Your Honor.
Yeah, that was directed to you. As I can see.
Yes, let me see what the original damages for the suit was $826. Let me see what she's looking at, some account statements that we sent her. Let me see what she's referring to. 1 second. Let me. Let's see.
And while he's looking, Mr. Cole, the validation document that you're referring to, what date is that document indicating?
Let's see. It was June 5th, 2017, the statement.
Okay, and did you make any other charges after that date?
No.
So when did you last make any charges or purchases in relationship to the Victoria's Secret account?
It had to be maybe like the spring of 2017, I believe it was.
All right. So I guess that's a part of the rub. Obviously, the truth-seeking indications of the court are significant in terms of trying to get at what the matter and deal with the actual amount should be. You are in default, and that poses some problems. Although you were not served personally, the petition for alternate service, and that results in the entry of the default. That's the issue here. And you just say 15 things about that, and that's not going to change that. So,
yeah, but I've been at my current address for over 3 years.
Yeah, it's probably not going to change a whole lot.
Okay.
Particularly where there was some kind of bill, they used the billing address as a basis to try and get you served. But we'll address all of that in just a moment. Counsel.
Your Honor, I did find the charge-off statement, which was the final statement for this account. It is from June 7th, 2018. That was when the account was charged off. And the balance at that time does match the balance in the suit, which was $826.66. There are statements after the date that she indicated that she was looking at. She may have made the last payment in 2017, but we charged it off, and the balance at the time is $826.66. I believe that was the balance that was attached to the original, or the statement that was attached to the original lawsuit. I'm trying to verify that right now as well.
Now for a moment, what's the date of the charge off? I have your lawsuit. I know what numbers you put in the complaint. And,
yep. The charge off date exactly is May 31st, 2018. So that's reflected in the statement. The statement attached to, it should be attached to the complaint.
All right. Now, did you receive a copy of the charge-off document, Ms. George?
No, I did not. I haven't received anything at my new address. The old address was on the register, in the court's register. So I haven't received anything. on this case. The first indication of this case was from my employer. That's the first I heard of it.
May I ask Ms. Dorch a question just quickly?
Sure, go ahead, sir.
Did you receive, you said you received our verification of debt packet to your
Yes.
address, correct? Okay,
Yes.
so you did receive that. The very first document in that packet is the statement I'm referring to that has the balance on it. It's page 1.
Yeah, it says $1,112.
That's the judgment amount.
Okay.
He's referencing something that shows the charge-off amount.
Yeah, that was maybe they put it in a different order. I mean, it's scanned as the last page for the judgment, but the very first, maybe look the page after the judgment with the account statement should be dated 2018. That's the document I'm referring to that was attached to the complaint that shows the balance at the time of charge off.
Yeah, I don't see that for 826. I see a few statements after that. It says 326, not 826.
Okay. All right, and I have attached to the complaint in this matter a billing that indicates a date of, looks like it's sometime in June 7, 2018. And that billing indicated $826.66. Of course, a part of what has been happening with this is there were late fees charged every month and interest charged every month. And I see that on this particular billing, it started out at $773.95, and the late fee was $37, and the interest charge was $17.72. So undoubtedly, there was the accrual of late charges and interest charges once payments stopped on this, and that likely explains the spread as it relates to the judgment. Let me deal with a couple of things in it. In the first instance, I don't find that there is a basis to set the judgment aside in this case, particularly where there is indeed some debt and obligation that inures to the defendant in this matter. The second thing is that the defendant has filed objections to the writ of garnishment and based those objections on essentially the same reasons for the motion to set aside the default judgment.
Mhm.
I do think that the defendant may be actually asking the court for some consideration other than a garnishment of the wages as a way to get this resolved.
Yes.
So if, have they taken any money out of your wages along this way, or did everything stop?
Everything has stopped.
All right, so what would be, I know it would be 25%, but what would that roughly amount to per pay period for you?
Probably about $169.
So about $320 or $330 a month. That's what that would turn out to, correct, ma'am?
Yeah. Yes.
So I could set up a partial payment plan, ma'am.
Okay.
And that would allow you to pay it by way of give you an opportunity to do that. What would happen under that scenario, Counselor, if I would suspend the garnishment as long as the payments are made, then the garnishment would remain suspended. If it doesn't, the payments are missed, then the garnishment suspension would be lifted and it would be enforced again against the wages. So I don't find a reason to set aside the judgment in this matter. I will, in alternative, as it relates to your objections, alternatively, I will allow for a partial payment order at $100 a month. And that order would commence, the commencement date would be the 17th of December. That would be when the first payment is due.
Okay,
And then each month thereafter at $100 per month. As long as that payment is made, the wage garnishment would be in suspension.
Okay.
So that's what it's going to be. The objections to the writ of garnishment are essentially denied on stopping the garnishment, suspending it.
Okay.
Well, the order for installment payments.
Okay, thank you.
All right, that's going to be my order in this case, and the court is preparing written orders in that regard. So, ma'am, you'll make your payment to counsel's office, to Mr. Berman's office, and I believe that that address is on some of the forms that you have. So the address there in Beam Farms.
Yes, correct.
Okay, okay.
All right, so you use that address. Should it be made, should the payment be made to Crown or to your office? How do you do that, Mr. Berman?
The payment should be made payable to Crown Asset Management, the name of the plaintiff, and then mailed to my office.
Okay,
And if you could, Your Honor, I just want to verify, was that $100 per month? I couldn't hear that 100% clearly, so I just want to make sure.
Yes,
Okay.
I said it at 100 a month. Yes.
Okay. Thank you.
All right.
And the court will prepare the orders, correct?
Yes, sir. All right.
Thank you.
All right, so you will get something in the mail, and you should get it way before the 17th, but even if you don't have that order before the 17th, you still make that payment so that you're not falling behind, because you fall behind. The
Okay.
suspension gets back in place, okay?
okay, thank you.
All right, thank you. Thank you, counsel. Good day to the two.
All right, thank you.
You too. Thank you, thank you.
All right, this is Michigan First Credit Union versus Tara Murphy. The case number in this matter is 14-113332. The matter is before the court on the following of objections to a writ of garnishment. For the plaintiff, Michigan First, your appearance at this time, please.
Good morning, Your Honor. Daniel Holzman, P2344, on behalf of the plaintiff.
All right, thank you, Mr. Holzman, and good morning to you, sir. And do I have Ms. Murphy here? I believe that she was here. Ms. Murphy, if you'll unmute your device, *6 will do that. If you'll unmute your device, you can speak to me now. Looking for Ms. Murphy. Karen Nat Murphy. Ms. Murphy, if you're on the Zoom, if you see the microphone on your device, then just click the microphone and it'll unmute you. If you don't have a microphone, hit *6 and that should unmute you.
Hello?
Okay. All right.
Hello?
Good morning. Yeah, I hear you. Good morning.
Okay.
All right, so you filed your objections to the writ of garnishment in this matter. This writ of garnishment is based upon a judgment that was entered against you. That judgment was entered on the 24th of September, 2014. The amount of the judgment is $4,949.13. You objected to the garnishment, indicating that as a result of COVID-19, you're not working at or full-time, you're working temporarily at a temporary employment agency.
Agency.
All right.
But this is the second time that I took them to court. These two cases supposed to have been merged. This whole case is supposed to be suspended. This is the second time this year.
All right. Well, I don't see anything on the court's documents indicating that the case is suspended. If
He
it
was
was
the,
no,
this attorney right here, he was supposed to merge two accounts together. He was supposed to merge them together. I had a court date. I have it at home. I have the court date and the judgment. And I also talked to the staffing agency, and I'm dealing with a lady in the payroll department. And she has the paperwork stating where another judge from 36th District Court this year suspended it.
All right, counsel.
Just trying
And
to
I'm
follow
working
up on my
temporary.
notes.
I'm not even permanently working enough to be paying. This is an old judgment. I'm trying to figure out why they keep coming directly at me solely.
Yeah, I mean, you have a judgment against you, and it is.
I know, but I'm not the only one. If this is supposed to be suspended, why they keep coming against me?
In a moment, I'm going to cut you completely off because you're interrupting me, and you know you can't do that. So I don't know why you think that that's something that you can do here. Here's the issue. The issue is that you have a judgment against you. They have the right to collect on that judgment, and there is nothing that has this in any kind of permanent suspension. If you came to court and a judge did not allow the garnishment to go forward for some reason at that time, that does not prevent the plaintiff from bringing an action to collect on the judgment at a subsequent time. Right now, you don't have any kind of stay or anything. If you, for example, if you were in bankruptcy court, then there's a such thing as a bankruptcy stay. But you don't have a stay on this case. You don't have anything that stops or prevents them from being able to file a writ of garnishment. So that's
Your Honor,
continue to happen. Counsel, I'm listening now.
if I can just clarify a couple things for the record, Miss Murphy does have a second lawsuit that is in the 36th District Court. I do not know whether or not that's in your docket or not, but there was a prior hearing earlier this year on an objection to a wage garnishment. According to the notes I have in my file, the court ordered Miss Murphy to file a motion for installment payments with respect to the wage garnishment that was issued in that other case. I do not see that a motion for installment payments was ever filed with this court, and therefore, according to my records, this garnishment still appears to be valid because I do not have any order for installment payments suspending the writ of garnishment.
All right, what case number is that other case, sir?
Pull an order for you. I believe it's 16111-832 GC.
1611. Yeah, it looked like I got too many numbers.
I got it.
Oh, she's got it. Hold on one second.
This was on post today. I guess it was just, I don't know what it was. It's something that sent with that patient with me about. Yeah, the top one is the case. And that's the other one is the other case.
All right, so I have the 16 case now. That's not my file, is it?
And I see,
Judge Giles.
Honorable- yeah,
Good job.
Yeah, this is Judge Giles' case. So, yeah, as Ms. Murphy indicated, she has two cases. I believe her from the moment she told me that. Those cases are separate cases in separate years. And although they relate to the same plaintiff, they are separate cases. So, ma'am, did you file a petition for partial payments?
I didn't. For which case? The first one or the second one?
Either one of them.
I don't think I did. As a matter of fact, I don't know. I don't think I did at all.
Gotcha. That's the.
But I remember meeting up with this attorney right here at 36th District Court. And I remember putting some kind of payment arrangement together with him. And this was a long time ago.
Okay.
But by me being unemployed, I'm not just unemployed. I'm just like when they shut everything out, they shut everything down with me too. I'm trying to get on my feet, and they keep coming at me like I'm the only case they have or something like that. They don't want to work with you, period. Because I talked to another attorney, and I can't think of his name this year. It wasn't him. It was somebody else pertaining to this case. They don't want to work with you to pay what you can pay. They want to tell you what they need. You can't give them nothing you do not have. I'm not going to be out on the street paying them.
All right.
Hello?
You still talking or you finished?
I'm finished.
Yeah, I mean, I get what you're saying. You got bills that you can't pay. The problem is that when you have a judgment against you, the law allows a person that has a judgment against you to pursue that in every possible way that they can. And they can compromise if they want to, but they don't have to. It would be the same thing if you had. Are you still listening or are you still talking?
Yeah, I'm listening. I'm listening.
It would be the same thing if you had a judgment against someone or some company. You had a judgment against me. Once you have a court order that allows you, that says that you have the right to collect a certain money, you can come after me any kind of way that you want. You can attach my bank account. You can garnish my wages. You can ask the court to allow a sheriff to come and seize property from my house, et cetera, et cetera, et cetera. There's a lot of things that can be done. The problem here, of course, is that you have two judgments against you. Total amounts of those judgments, one is $10,900, the other is $4,700. So when you put it all together, you have about $16,000 in judgments. Now, there are a couple of ways that goes. One is that if they pursue you and they can't collect, then they can't collect. They'll keep pursuing until they figure out a way to collect. But they have the right to pursue you and try to collect. If you're not working, then that means they won't be able to garnish your wages. If you are working somewhere and you have received any money, they'll be able to garnish the wage of any money that you receive, whether it's part-time or full-time. If you don't have any money in the bank, they won't be able to attach a bank account. But if you have money in the bank, they can attach a bank account. If you are on somebody else's bank account, they can attach that account, even though the assets may belong to somebody else. So that's the problem, or that's the nature of the problem. You have a judgment against you. And you're right, with the pandemic, a lot of people have gone through a lot of different stresses because of the inability to get work and to pay bills and what have you. But once the court lifted, or I should say, once the state and the federal government lifted the various stays that were in place, then these agencies are able to begin collecting again. So there's no stay in place. During the pandemic, there was a stay for a period of time that nobody could go after anybody, et cetera, et cetera, et cetera. But all of that has been lifted now. And so now the creditors can come after you in any way they want to, as long as it is in compliance with the law. That's what's going on. What would make sense, and like you said, it's a truism. You can't. You didn't say it this way, but the same thing. You can't get blood out of a turnip. What would make sense here would be for there to be a payment arrangement that is consistent with both of these files, and then you keep the payment arrangement, and then you don't have to worry about your wages being garnished. But if you don't have the wherewithal to do that, then you'll keep dealing with the harassment of filing these actions, because they're going to be constantly looking for how can we collect for our client on these judgments. So I mean, it's a conundrum. It's a hard situation. But today, what's in front of me is the objections to the writ of garnishment, and the fact that you're not working or working part time. It doesn't really state a valid objection. They can collect if it's part time, or they can collect if it's full time. They can collect up to 25% of the amount that you would normally receive. One of the ways to deal with that is a partial payment agreement. But I know because of the lack of wages that you have, that compliance with a partial payment agreement is going to be difficult. In this situation, you basically would need the kind of thing that would make sense here to try to keep the garnishments off of you is basically about the lowest payments that can be set on this. Is the case where there's $4,800 is about $50 a month. That's a really low payment. In a case that's
How
about,
much is it?
no, I'm coming to you. I want you to hear me out. In the
I'm talking
case that-
about how much you said that the payment
Yeah.
arrangement will have to
Oh.
be.
I'll put a wrap on it in a moment, okay? So you got two cases. One of them is about $4,800. The other case is 10,000, well, right at 11,000, 10,900. If you-
That's supposed to be suspended.
Well, all right.
I had
well,
a paperwork.
Okay. All right, well, I suppose then, that is suspended, so that one is not in front of me. That's another judge's case. All right, so, the one that's in front of me is the one that's, involving the $4,800. And that's the one that you're being garnished for in this particular case. So one of the ways that you can deal with the garnishment here, is to file a petition for partial payments and seek to make a partial payment that will prevent the garnishment from being executed on this matter.
Well, they already took some money.
Okay, well, they'll continue taking the money as long as the garnishment is in place, is what I'm saying to you. You can file a partial payment, petition for partial payment, and that petition could likely get you into a monthly payment that will be less than what the garnishment is. That's the point in terms of how these things work. At this point, I don't see any really alternative here but to deny the objections as their whole basis for the objections that are filed here. And I would release the funds that were withheld to the plaintiff. And that writ of garnishment will remain in place. You can file a petition for partial payments, and if you're granted that petition, then the garnishment will stop as long as you're making the monthly payments. All right, that is my order in this case. I do wish you well, ma'am and sir. Good day to you.
Nice day, Your Honor.
All right, this is American Medical Center versus City of Detroit. This is case number 21-156457, American Medical Center versus City of Detroit. Are any other parties on this matter, your appearance?
Which one? Oh, she said, she did call, the clerk called, the attorney called, and she said she was in another courtroom, her secretary said for, American Medical, she was in Judge Giles' courtroom.
All right. Is anyone else here who believe that you have a case in front of me?
Yes, hello, Your Honor. This is Carlos Jamie. I'm here with Next Gen Drywall.
What's your case number? What's your case?
Case number 211622285.
Just one moment.
Can you say the case number again?
211-622-285. Okay, what's the case number again, sir?
211-62285.
Oh, 22. Okay. That's drywall, Next Gen Drywall, that's for Judge Giles.
Yeah, you're in the
Next
wrong.
Gen
You're in the wrong courtroom. You need to be in Judge Giles' courtroom. And that courtroom number, let's see, we're gonna get that.
360-537-0000.
All right, so you
I
got
got that.
you got,
Excuse me, can you give me that number again? Sorry.
360 537. Yes, 537
Okay.
0000.
Okay, yeah, I got the wrong ID number. That's what it was.
No problem. And you tell them that you were in Judge Coleman's courtroom so that they'll know that you were already here and if they need verification, I can verify that you're here.
Thank you.
All right, thank you, sir.
All right.
Hey, how you doing, sir?
Hey, how's it going?
All right. How you doing, Officer James? What judge you here to see today?
Hey,
You're going in and out. I can't hear you.
Yeah, you got a bad connection
I'm here
here.
for
What's your, okay, you it
Mr.
seems
Barry,
like
case.
yeah, you got two devices. That's Good morning, Mr. James. It sounds like you're on two devices, and if you got two devices, that doesn't work very well. Are you on the
device, sir?
yeah, well,
Should be probably with Judge
you're
Ford.
coming through real clear now. All right, so are you on a criminal matter or are you on a civil matter?
Let me check here. I believe it's civil.
Yeah, you're in the wrong courtroom, and
Yeah,
let me get you to the right spot. I think you need to be in Judge Ford's courtroom. And that,
yeah, for Judge Ford.
360-335-0000. That's the meeting ID number that you're going to need to get into the courtroom. It's 360-335-0000.
All right, thank you.
Yes, sir.
all right, officer, good day, sir.
Good morning, sir.
Good morning. How are you this morning?
Great. What's your case number there, sir?
You need just the last three digits or the full case number?
The last three will work.
I got it.
612. Oh, perfect. There we go.
All right, and it's set for, it looked like I have it set for 11 o'clock. Anyway, this is case number.
Yeah, I'd like to be.
Let me call the case 2016-8610, Auto Advanced of America Incorporated versus Ronique Phillips. The matter's before the court, looks like on a motion for entry of default. Counsel, your appearance at this time, sir.
Good morning, Your Honor. May it please the court, Keith Nathanson, P41633, on behalf of the plaintiff, Auto Advance of America.
All right, thank you, sir. So I understand that you're here regarding a supplement regarding damages in this matter. This is a fact case.
Yeah.
We're just checking also.
Philip, yeah. Yes.
All right, I don't have a complete file on this. I just have a slight amount of paperwork. And I had it set for 10 o'clock a.m. Is that the time you had as well, Council?
The notice that I received, Your Honor, had it set for 11.
So let
Renee
me,
had the file. Judge Nance had them somehow, I don't know, somehow they must have sent it to her chamber, that's what it's saying. She has the file. She's supposed to give it the file, but they have the file. They said she's wrong for it.
so it should be hers.
No, it's your case, but they gave it to her. They put her name on it. I don't know why.
All right, so the case, now, Mr. Davidson, the case is sent to Judge Nance Adams' courtroom. But the little jacket with the information was sent to my courtroom, and the computer says it is actually my case. So I'll address it. I'll address it at 11 o'clock. Was there, in fact, a notice from us?
Yeah, I sent a notice on this, Renee did actually, but she must have been in here that day. Her clerk, she sent a notice out.
All right, Mr. Davidson, I'll get right back to you, sir.
All right, very good. Thank you, Your Honor. I appreciate it.
And we're on the record in 21-156-457. This is American Medical Center versus City of Detroit. And good morning to the two of you. Your appearance for the plaintiff.
Good morning, Your Honor. Nice to see you again. Joe DeCoupe on behalf of the plaintiff.
All right, go ahead and put your P number at this time.
P84445.
Thank you, counsel. And for the City of Detroit.
Yes, good morning, Your Honor. Robin Brooks on behalf of the City of Detroit, P47787. This is day and time set for our motion for summary disposition.
All right, and I remember something about this. It was adjourned, I think, because plaintiff's counsel needed to look at something further. Somebody update me on things.
Your Honor. Oh, I'm sorry.
No, Joe, go ahead. I'm sorry.
Your Honor, we've looked over sister counsel's brief. We didn't have it originally. We do have it now. Plaintiff did not file a response as we believe that Ms. Brooks's articulation on the facts are what's a good word? Are correct. And I guess that's the best word I can come up with. They're factually accurate, I guess is a better way of saying it. And at this time, we leave it to Your Honor's discretion on how he would like to proceed. But we did not file a response, and yeah, I'll leave it at that, Your Honor.
Your Honor, and I thank Brother Counsel for making that statement. So at this time, we are requesting that the motion for summary disposition be granted with prejudice.
All right, Ms. Brooks, tell me a little bit about the motion, if you will, for the record.
The motion is based upon full accord and satisfaction. American Medical Center, prior to Brother Counsel's complaint, was paid a reasonable amount based upon the the idea of full accord and satisfaction. They did cash that check. We certainly had put on the check that this was being tendered to them based upon full accord and satisfaction, based upon the 4 service dates that was listed on the check stub. And it would be any person's understanding when you cash a check and that the condition has been conspicuously stated and noted to the person receiving payment, that if they cash it, then they are accepting that payment as in full for the the amount of services or the amount of services rendered.
Thank you, Madam Counsel. And Counsel, you sure you don't have a vigorous argument against the statements Maybe you're in, sir.
Your Honor, the check did have full accord satisfaction. There is an argument to be made as far as the balance billing and McGill and all the other case law, but Your Honor, it clearly states full accord and satisfaction. I believe that this court has previously in the past. I don't want to speak for Your Honor or this court, but I believe they have ruled in such a fashion where a full accord and satisfaction when it's displayed promptly on the check and it says it clearly and in English and as big as it does, there's not really an argument to be made other than we don't like it, Your Honor, but we can't do anything about it. They cash the check.
Very well. Well, it seems to me that that's exactly where this case is. Motion for summary disposition will be granted at this time, and I'll sign an order consistent with the same, and that would be a final order in this matter.
Thank you, Your Honor, and have a great
Thank you,
day.
Your Honor.
Thank you, Brother Counsel. I'll see you again.
I'm sure we will, Robin. I'm sure we will. Your Honor, it's always a pleasure to be in your court.
Yes.
Likewise to the two of you.
Thank
you. Thank you, everybody. Have a good day.
I don't know why we're there. Let me get that file for today. It was her case. For some reason, they gave it to use her sheet. I don't know what she had the case. Hey, Renee, I'm looking for a case. It looks like it was switch of your trial case. Give me Judge Coleman. And you have the file. Mm-hmm. Mm-hmm. You scheduled it for the 17th. But it says you have it in the chambers. Uh, 2016-8610. 16. Yeah, 2016-8610. You had it on 10/15. I don't know. What you say you had it on? Mm-hmm. Because it was her case, but somehow they switched to Judge Coleman. Yeah, I don't understand why they do that. Like, why are you switching the judges? Like, what is?
Apparently, there was some issue she raised with damages. I don't know the issue. So she set that up.
No, what can't? See, yeah. Well, I think they probably sent it to you right because it was her case, but then they somehow switched it to us. So it said you had to file on the 15th. So when you get a chance to we get that, yeah, get that file. When you get a chance to bring it. Yeah. All right. Okay. Yeah. They're gonna have a meeting with these default judgments. Oh, okay, okay, all right, no problem. Thank you. Here you go for the last one, the last case.
Come there and gifts.
Oh.
You
no.
gotta take it out.
Oh. Okay, yeah, okay, yeah. Okay, thanks. All right.
Hey, how are you?
Good, how are you?
Good. Mr. Nathanson, just give me one moment. I'll be right.
All right, very good, Your Honor. Thank you.
All right, this is case number 20168 This is Auto Advance of America Incorporated versus Virginia Inspector Relief, Virginia Phillips. The record should reflect that an application for judgment was submitted to the court, and on submission of that application, the matter was before the Honorable Lydia Nance Adams. She then required a hearing with respect to the claim for damages herein. And on requiring that hearing, somehow case has migrated, navigated, whichever way you want to put it, to my court. I'm hoping that the defendant has the information to be here, because I know that the Zoom number on this case, on the notice it appears, is 534. And of course, this is 336. All right, and let me, your appearance at this time for the record, counsel.
Good morning, Your Honor. Keith Nathanson, P41633 on behalf of Auto Advance. And just with respect to the notice, I would advise that I was sent to the other Zoom as well, and they were very kind to give me the proper Zoom as soon as I did and let me know that it was in fact here. So I would presume that if the defendant did the same thing as me, the defendant would receive the same information.
Yeah, I would suspect so. I guess so, and when you went to that other Zoom, that was in fact, to the best of your knowledge, was that Judge Adams' courtroom?
I believe so, yes. And actually, I have another matter that was also scheduled at 11 for Judge Adams. Said I'm actually on my laptop logged into Zoom as well, and I do not see the defendant logged in on that Zoom hearing.
Okay. All right, and the record should reflect it is 12 minutes after the 11 o'clock hour in which this matter was set. Moreover, it appears to me in this matter that that defendant has not previously appeared as well regarding this matter, and that's why it was in the nature of an application for default. So, one of the things that we find from time to time is that when there is a complaint and the actual document or contract is not attached to the complaint, it raises some concerns as to the actual amounts and how the amounts were arrived at, whether they are tethered to the contract as they should be. And of course, in this case, it indicates in the complaint that the defendant has the copy of the training of the contract, and there is no contract text attached to the complaint. And the plaintiff seeks to avoid that by pleading an account state. And then one of the challenges here is contracts for the sale and purchase of motor vehicles that involve other languages that have substantial impact on the bottom line, i.e. 15% of the balance being a liquidated damage term or attorney fees and other kinds of provisions that might exist in the contract, again, which is not attached to the complaint, which is one of the challenges here. So tell me about this.
Yes, Your Honor. So actually, and I would note to the court that on the 9th, I did send to the court by fax and by regular mail a copy of a supplemental brief in which I attached the actual contract, which I actually had to reduce to 4 pages because it is a long document. It is a retail installment contract for the purchase of a 2007 GMC. That copy is provided to the defendant along with a copy of the RD 108 application for the title at the time the vehicle was purchased. Also, I attached to a copy of our supplemental brief a letter which was addressed to the defendant March 18th of 2021 that the vehicle actually had been repossessed, the 2007 GMC repossessed and sold, and listed the actual amount of the deficiency balance on the automobile as well. So I have provided the court with those documents providing what the deficiency was at the time of the vehicle sale at auction. The contract does provide for that 15% attorney fee if litigation is required.
Sorry to interrupt,
I apologize.
but you have an appointment soon.
That's my practice management system. Always likes to tell me when things are going on, much to my chagrin sometimes.
That you have it in a female voice because that's typical, right?
I've been using this.
What to do.
Yeah, I've been actually using this for 25 years, this practice management system, and it's always been the same voice. So I'm used to it by now. But
try a male voice to see.
It might be worth a try, but in any event, yeah, this was brought as a breach of contract amongst other things. The contract was provided to the defendant, as I indicated, upon purchase of the vehicle. That is required by my client's licensing with the state of Michigan. As I've indicated, I submitted it also with our supplemental brief as well, the deficiency notice as well. Ms. Iverson has not responded to the complaint. The amount prayed for in the complaint was the deficiency balance plus the contract balance.
All right, so I think you're saying that the amount prayed for was the deficiency balance plus the 15% attorney fee.
Correct. Yep. In paragraph 6 of our complaint, it does pray for that as well. Yeah. So the 6247.36 plus 937 in attorney fees for a total of 7184.46.
And so your judgment is seeking 8,500, almost 8,600.
Let me take a look at the default judgment that was submitted.
It may need to be amended.
The judgment that I'm looking at says damages 7184.46, costs of 105, $75 statutory attorney fee, for a judgment of 7364.46. That's what I show for Ms. Iverson's file here, unless I'm looking at the wrong file. You know what?
Yeah,
Oh,
this
you know
is
what? I apologize. I'm looking at Judge Nance Adams' file. Oh, apparently I'm operating in a high state of confusion this morning. Let me look at the correct file here. So,
That's Phillips.
yes, Phillips. Yeah, I have far too many windows open. Oh, yeah, it does look like there's an error on this default judgment that I see here. It looks like my staff may have put the wrong numbers in for Ms. Phillips. So we would need to resubmit a judgment that's consistent with the complaint. Obviously, the costs and statutory attorney fees would be applied as well.
But you're getting actual attorney fees, so I don't know that you should put the statutory attorney fee attached to it.
I'm happy to admit that. That's fine, Your Honor. I have no problem with that.
So, yeah, I saw your actual going back and doing the work up, getting the paperwork on this, on the deficiency really helps with driving what the balance should, what the judge should.
Correct. Yeah, that's why I wanted to have the court the actual deficiency balance letter, just to see that she was notified. And that is actually a regulation from auto lenders with the state of Michigan that a deficiency balance letter have to be provided upon sale or liquidation of a recovered asset.
Yes, sure. I'm so aware of that. I don't want to tell you the long story about it.
Maybe another time over a cup of coffee.
For sure. And then, of course, being a judge for 29 years, I know I look too young for that, but it is true.
I would have put you at 29 years old, not 29 years of practice, but what do I know?
Started in the crib. So I'm looking at the 6743, the 15% as an attorney fee, and then in relationship to this matter, I do see a calculation of cost at 195, and the combination of those three amounts should constitute the judgment.
And I will resubmit a judgment that is consistent with that and omit the statutory attorney fee as well.
Very well, counsel. You want to email that to me?
I would be happy to, Your Honor.
Right, that's going to be Latifah, LATIFAH.Hunter@36, that's 36th District Court.org.
Okay, I will have my staff prepare that and email that over. Should be over there sometime today, as soon as I conclude with Judge Nance Adams' matter.
Thank you. For the record, the court grants judgment as prayed and as set forth on the record hearing and anticipates the submission of the order charges.
All right, very good. All right, thank you for your time today, Your Honor. I appreciate it. All right, stay safe.
Likewise, sir.